Hello, everyone. The release of the convicts in the Bilkis Bano case is shocking to anyone with a minimum sense of justice. Now, with the Gujarat government filing an affidavit before the Supreme Court in response to the petitions challenging the premature release of these convicts, we have more information regarding the decision-making process. So in this background, we are having a discussion with Advocate Shobha Gupta, Supreme Court lawyer, who has represented Bilkis Bano in the previous proceedings. Welcome, ma'am. Thank you so much for joining us.
Thank you, Manu.
So, ma'am, now with the Gujarat government filing an affidavit, it is clear for the first time that the central government has approved the decision to grant remission for the sentence of these 11 convicts. It is also clear that the CBI, the prosecuting agency, the investigating agency, the CBI, and also the presiding judge of the trial court, the special CBI judge at Mumbai, both of them have opposed the grant of remission. Now, before coming to ma'am, I'll just read out one small paragraph from the objection made by the presiding judge for the benefit of our viewers. Now, I am quoting from the opinion given by the presiding judge. In this case, all convicted accused were found guilty for rape and murder of innocent people. The accused had no enmity or any relation with the victim. The crime was committed only on the ground that the victim belonged to a particular religion. In this case, even minor children and pregnant women were not spared. This is the worst form of hate crime and crime against humanity. This has shocked the conscience of society, and it affects society at large. The convicted prisoners were given double life imprisonment for different offenses. The object of the government resolution is not to give benefit to such convicted individuals who have committed gang rape and murder of innocent individuals. Hence, the court is of the opinion that they should complete minimum sentence and they should not be granted premature release. This was the opinion of the trial judge. The CBI also said that the offenses are serious, grave, and heinous, and they should not be given any leniency. So in this context, do you think that the decision of the central government and also the state government to approve the release by overruling the objections of CBI and the trial judge, do you think it is legal? And also, do you think it is proper and just?
So when you were reading this, the special judge's opinion or the report, I wanted to say you said it all. Like, this report says all. In fact, it is also not saying something what is completely had to be conveyed. A crime of this nature. And how come and what is the basis? Like, I have seen the entire affidavit. I do not see consideration of this report anywhere. So if this is a mandate of law, mandate of CRPC, which says, and 5 judges bench in Sriharan says this is a mandatory requirement, it cannot be diluted. So if that is the mandatory requirement, two of the major stakeholders, who are those two major stakeholders? Prosecuting agency and the convicting court. Both have said no, and not by, a 4-liner, by a detailed report which deals with the nature of the crime. It also says, and if you, Manu, you must have gone through all these circulars by now, and the circular of Government of India, which says, and judgments also, n number of judgments, which says convicts of rape, gang rape, and murder. There has to be an exception, cannot be granted benefit of premature release. If you see, the special court says, special judge says that minimum 28 years had to be gone by them, minimum 28 years. And the central government has, like, what is the most shocking is central government has granted the concurrence. And state government, on what basis? State government, when two major stakeholders said no, Third major stakeholders had given concurrence, but where is that examination, or where is the opinion based on three of them? So according to me, this has to be examined. That can you do that? Can you completely ignore the opinion given by the two major stakeholders?
So do you think that the state government and the central government, they should have explained why they are not accepting the opinions of CBI and the trial judge?
So tell me then, what is the point of asking for the opinion? If that can be ignored without even going into, without even referring to, without even dealing with them, then what is the point? Why the requirement of mandate? The section says a mandatory requirement. The 5 judges bench is here and says it is a mandatory requirement to be complied with. So if this is only a mechanical exercise, that to complete the requirement of law, you ask for everybody's opinion and then throw it in a dustbin. Because in the remission, we don't have a remission order yet. Remission has been granted finally by an order of 10th of August 2022. The affidavit says so. Affidavit says this is not a premature release on the basis of some Azadi Ka Amrit Mahotsav. This was under 432 when we were examining their application, taking opinion, concurrence, then final view taken after considering all the material. Now, when you say considering all the material, where is the consideration on these two material? And if it is a mandatory requirement of asking for an opinion, you sought for an opinion. Who else, tell me, can be the better stakeholder? Who has a if you compare 4 stakeholders, these two are the most important, the prosecuting and the convicting agency. Both have said categorical no. If you ask me, I'll say these two opinions have been thrown to dust.
And the reason cited by the state government are that they have completed 14 years of sentence and that their behavior in the prison, that was a good behavior. So do you think these two are the only requirements for granting premature release?
No, Sophie, if you see all the judgments, line of judgments right from beginning, right from 1972, even before that, we have now we have compiled all the judgments. We have virtually a Bible of all the judgments on premature release and remission and consideration. The factors which have to be gone into is conduct, period undergone, the nature of the crime, impact on the society. So if you assume somebody has become a saint of highest order, the best of the character possible on earth, and the crime is like he had murdered 100 people, it's still court, for some good or bad reason, not granted death penalty, or death penalty was commuted to LI. And he became a saint of highest order. He's serving everybody in jail and whatnot. Court would say so very well, and the agencies would say very well, now, since you have become a saint, we would ignore the nature of the crime. Here, what is the nature of crime which the special judge speaks in volume? In fact, the judgment also, if you see the trial court judgment and the high court judgment, in fact, Supreme Court, while granting highest compensation ever to a rape victim, they all said this is a crime which was a communal crime.
Yes.
So it is not an allegation alone. A judicial notice has been taken to this aspect that was a communal crime. It was a hate crime against a particular community by a people of a certain community. A pregnant woman raped. Sorry, I'm so sorry, I'm correcting that. A pregnant woman raped. Her mother raped and murdered. Her sister raped and murdered. Her 2 minor sisters murdered. Her 2 minor brothers murdered. Her 2 fufa murdered. Fufi murdered. 3 cousins murdered. Like, how many? Like, can there be a grossest? Can we say this is not actually the rarest of the rare case? Honestly, death penalty was the most appropriate penalty for this case. But in such a case, remission being considered without even considering the nature of the crime. I did not see anywhere except CBI and special judge even referring to the nature of crime. None of the agency. And if you see that entire affidavit where there was a proforma, they are giving details of the nature of the crime in the proforma, they don't even mention pregnant women raped. Innocent people, there was no enmity. All these are the factors to be considered. It is not a case of enmity, some provocation. Innocent people running for their life, saving it, were followed for 3 days. Just see the nature of the crime. They were running helter-skelter to save their life. They were followed for 3 days. That means somebody was hell-bent to kill them. So this was a hate to a certain community in such a desperate manner that they were followed to even a forest, caught, brutally raped and murdered. It was a brutal murder. When you're smashing a child of 3 years and smashing on a stone, who does it? Can a human being do it? So they had crossed all limits of being, completely bewildered.
And now today, while examining the records, it has come to light that one of the convicts, when he was granted parole in June 2020, he was accused of committing another offense of molestation, and another FIR is charged. He has been charge sheeted, and the trial is pending. So
twice.
Yes. So even if on the ground of good behavior as well, do you think there is an adequate consideration on that aspect?
Good behavior. I have so much of the material to actually place on record. No good behavior. My point is very clear. How come see, this is not the sacrosanct ground that on the good behavior and completion of 14 years, you can say we have no option but to grant you bail. Grant you premature release. It looks like a case like this, as if the government is sitting and saying, oh, now you have come, your application has come, you have already completed 14 years, your conduct had been good. And how are they examining the conduct? Somebody who jumped parole, furlough. Twice, this Mithilesh you are referring to, twice he was, 2 cases have been registered in June and July. And a charge sheet has been filed in one of the cases. Both the cases are pending. So how come even his case has not been distinguished? In fact, regarding one of the convict, in April 2022, when he was asking for parole for few days, the High Court of Gujarat declined that by saying, we have received the report from the jail authorities. Reading the jail authority report, on the basis of the same, he is not entitled for parole for 15 days. 15 days or a month he was asking for. In April 2022. 4 months down the line, they are out for all life. So examination, and since we do not have the benefit yet of the remission order, we do not know, have they examined each and every case individually? So to say, these are the jail records. And if you see jail superintendent and advisory board's report, I personally do not find even the finding of good conduct is so correct. Which is, again, I'm saying, not sacrosanct. Assume it is a good character. Assume they were very good character or conduct was very good. Is still on the basis of the nature of the crime, they could not have been granted this benefit.
And also,
how come you allow as a government to come 11 rapists and murderers to come on road, room free, on the face of the victim, who alone survived? 14 killed.
And also, there are some reports which suggest that all these convicts, they have endured over like 1,000 days of parole during the sentence. So they have been
exceptional case. I tell you, exceptional case of leniency by the authorities. So initially, can you believe this, that initially, despite the fact that she named every single accused, they were all neighbors. They were all neighbors who were coming and buying milk from her father. She is born and brought up within, like amongst them. So how would she not name them? They all were named. Still, they were let go. Closure report filed by saying that they are not traceable. Magistrate closed the case. It's only because of Supreme Court it was reopened and fresh investigation was done. Matter was transferred to Bombay. They were convicted. High Court convicted. Supreme Court convicted. So agencies have come. All the criminal justice system agencies came to the aid of Bilkis. But the moment it went back to Gujarat, Bombay says, the CBI says no, Bombay special judge says no. The moment it went back to Gujarat, unfortunately, all leniency came to their way. How do you get parole like this? 1,000 days parole and furlough. So if you see this, effectively out of 14, 4 years they were out.
Right.
So in few cases they're 10 years, in few cases 11 years, few cases 12 years. These are the period undergone. And this is the minimum. And one more thing which we are missing again and again, that the special judge said it is double LI. How are we going to interpret this double LI? If you see the judgment is categorically saying LI for X offense, then LI for Y offense. So how much mitigation, like how much of the liberty and leniency has to be granted to them, and how liberally their case has to be considered? Like, I'm amazed. Today, Bilkis is worrying for her safety. Bilkis is, looking for security and safety and hiding herself. Why? Because her rapists are out on road. Somebody was asking me yesterday in an interview that, are you asking for security? I said, why should I ask for a security? Because the rapist and the murderers have to in bulk. 11 of them have to roam around free on the road. She should live in an open jail. Why not put 10 police persons around each one of them? If the government is so keen that they should be out, then ensure Bilkis's security by putting security people around each one of them, so they are not free to actually harm her or anybody. It's not only her. We as a society are concerned when rapists and murderers are left, are allowed to roam around free on the road and in bulk. Can you imagine a case of this nature? I often wonder, a pregnant lady, we take care of her like, with gloves in hands, like we protect her like anything. She was pleading for mercy to them by saying, I'm like your daughter, I'm like your sister, I'm your neighbor, you know me, you know our family, please leave me. Like all sorts of pleading of mercy she could do to them. And they were still barging upon her multiple times. How on earth we can think of granting premature release to these kind of criminals?
So since there does not seem to be a proper application of mind by the authorities, so do you think this is the decision is due to any extraneous reasons, that either because they enjoy some kind of special patronage or privilege? What could...
That I would not. That I would not really enter into that area. There may be, may not be. I would not enter into that. I'm so sorry. I would avoid entering into that.
Fair enough. Fair enough. So before we conclude, so do you think what could be the message the release of these persons what is this decision sending to the society? Because of late, there is a lot of campaign and measures taken to create awareness about gender justice and protection of women. So in that context, when we release 11 persons who have been accused of grave crimes, so what is the message that the authorities are sending to the society?
No words, honestly, Manu, to put it very, clearly, or maybe in an apt manner. I really don't have words. I'm loss of words when I have to explain this. If I have to say personally, how do I find this? It's threatening. It's threatening. It's devastating. It's so disappointing that you fight for justice. It's difficult for a person who is raped, who lost 14 members around her. She lost the entire family web around her. For a female to have female members around her, a family, for anybody to have a family around her, but especially to a female to have a female members around her, everybody, she lost each and every female close relative around her. Mothers, sisters, fufi, cousin sisters, everybody. She still, collected courage because of the support by social workers. The system came to her aid, that she could put up a fight for 17 years. So Bilkis became an example for other rape victims, that you fight for justice, and maybe it's a long fight, maybe it's a very, very difficult fight, but finally you can get justice. Now this comes on your face, that what justice you are talking? Why should I fight? In fact, I got a call from one of my clients. She said, are you still advocating me to fight for, she's again a rape victim, fight for justice? Is this the end of the tunnel? That long fight, it is so difficult for a rape victim to come and even to tell the lawyer that I have been raped, to explain, just look at their eyes. It's so traumatic each and every time to detail that. Bilkis, when NHRC commission visited them, team of the commission, including the then chairperson, I'm not putting the name right now, she said, I have not been raped once. I have been raped again and again every time when the authorities come and I have to detail it again. She still put up an extremely brave fight just to see justice. And how come the justice be denied like this? So 17 years of fight, within 5 years, in 2017, we were celebrating this, that the conviction has been upheld, or that she got the highest ever compensation. And within 5 years, she's back to, worrying for her safety, worrying for the things. She has daughters, grown-up daughters. So this is, honestly, if I have to put it in one word, I would say threatening. If the authorities can take such, unmindful, unreasonable call of premature release to criminals, convicts of rape and murder, multiple rape and murder, gang rape and murder, multiple murders. So this is a threatening, precedent also. Are we looking for this society? We would be around within a short span of, in our criminal justice system, it takes years for a matter to get decided till the last court. Meaning thereby that by that time you are fighting your battle till the last risk, then fighting this out. It's always a threat. Few days back, a person who was a rape accused, he during trial was granted bail. He's a police person. So we came up to Supreme Court, and Supreme Court then finally interim bail he got. Supreme Court cancelled the bail. He was asked to surrender. He surrendered. Within few months, he was granted bail by High Court. And the first call of the victim was, now what do I do? How do I secure myself? He would take revenge. that I dare to take up a case against him. Now, this is a scenario that you as a victim are always so worried about your safety. Because most of the time, these people have clout. So the system would have to ensure that they would not be coming back on your face immediately after, a fight and within few years of the fight. And they have to be punished. They have to be, this is according to me, not even a proper punishment for them to undergo. 14 years in a murder, which is a, one-time murder, one-person murder, simple murder, 3 LI has been granted and they have been allowed to come after 14 years. Now, what is the difference between that 14 year and this 14 year? If the crime of the nature of the crime is so extremely pull apart, but both the convict can come out in 14 years. Now, is this the law we are talking? For a legal system or for the state government, are both the accused similar? Or both the convicts similar? That who has murdered someone was given a death LI as a punishment sentence, and he asked for remission, he granted remission within 14 years, on completion of 14 years. The other person who is a rapist, murderer, gang rape, who has committed a gang rape with so many persons multiple times, and he is treated with the same yardstick. What kind of message we are sending? The point is, what kind of message we are sending? Are we okay with this kind of society? Society having all these people around, roaming around, and this sense of security to the criminals? Don't worry, you will be out in few years. And then good number of parole and furlough. So, in fact, they are handled with kids' gloves in this case.
Right. So, thank you so much, Advocate Shobha Gupta, for sharing your views on this very extremely disturbing topic. Thank you so much.
Thank you. Thank you.